Assalamualaikum warahmatullahi ta'ala wabarakatuh and a very good day. Chambers of Pari and Associates will be presenting Section 8, which are Motive, Preparation and Conduct. The members of Chambers of Pari are me, myself, Nur Najwasyazwani Abdul Nasir. Together with me, Nuradriana Batrisya binti Mohd Tiffla, Afiq Syafi bin Imran Hadzalie, Izzat Fakhri bin Halimi and Parimitaa Krishna Moorthy. Evidence refers to any clear indication that a certain individual is responsible for committing a crime. The establishment of an evidence shall depend on a few elements to secure a conviction that is done by a wrongdoer or to acquit an innocent civilian. The question arose on what are the elements that shall be in presence in the evidence provided by the witness in the court. Section 8 of the Evidence Act 1950 possesses the answer to this, where it sets down three elements, and they are motive, preparation, and conduct. Section 8 of the Evidence Act 1950 explained the evidence that shows motive, preparation, and conduct that must be given directly by a witness who perceives it. These are the important elements that the court or judge has to take into account before according to conviction or acquittal to any person accused of any offense. The elements or principle of motive, preparation, and conduct will be further explained by my other members.
And I will continue the presentation on the element of motive. A motive can be used to establish intention or mens rea for a criminal case. In Public Prosecutor against Azilah bin Hadri, motive was established as a common intention of the respondent, which is applied for two persons who intend to commit a crime together. In addition, the existence of motive may support in finding an accused guilty, but person cannot simply be charged for an offense just by having a motive to do a particular act. However, in the absence of any motive does not weaken the case or guilt the accused. Supported by the case of Yak Buntai against PP, it was stated by the court that in the absence of the criminal act, motive is indeed insufficient. The case proved that the motive itself is not enough to convict a person guilty. If intended to be used in court, the motive must be proven to exist and must be indirect evidence. However, motive cannot be proved by hearsay evidence. For example, in the case of Karang Singh against PP, the evidence of motive was rejected by the court, which was given to the deceased son by stating that it was only a repetition of what his father had said to his son before his death. Not only that, but a motive must also be proved to exist in relation to a particular crime. In the case of Muhammad bin Rahman against PP, Datuk Mokhtar Hashim and PP, where motive was used as evidence not to establish the offense of murder but to support the case. Lastly, a bad relationship may establish the motive for a specific misconduct. For example, in the case of T. Hock Kyong and Public Prosecutor, the appellant was seen at the moment holding a knife. This is a clear example for the motive to kill.
Preparation is the second element needed to be proved for Section 8 of the Evidence Act 1950 for it to be applicable in admitting a piece of evidence. Preparation is the process of setting up the equipment and plans required for criminal conduct. It is a preliminary act which leads to the commission of the offence. A piece of evidence to a preparation is relevant as explained in the illustration of Section 8, Clause C and D. Illustration Clause C provides situation where A is accused of murdering B with poison. If A has possessed any poison similar to B, such evidence is relevant under preparation. Another illustration of preparation under Section 8 is given under Clause D. Illustration Clause D inquires the validity of a document as a will of person. Situation such where A has inquired any provision of the alleged will at any time near the will was alleged. In this situation, if A has expressed his or her unsatisfactory expression on the draft of wills are considered relevant evidence. From these illustrations, evidence tending to show that the accused made preparation to commit a crime is admissible. Preparation is one of the four steps of committing a crime, according to Ajaib Singh Judge outlined the case of Tiang Yah and another against PP, where it was stated as intention to conduct crime, preparation for its commission, attempt to commit a crime, and the actual commission of the crime. It is therefore clear that committing a crime requires the completion of all four processes. Hence, evidence that only shows preparation does not constitute a crime.
Today I will be presenting on the on 2 cases under preparation. Well, the first case is Public Prosecutor and Azila bin Hadzalie. In this case, the preparation was established into 2 factors. First one is the arrival of the respondent at the crime scene even before the murder has occurred. The respondent's car was seen entering and exiting Kota Damansara Toll Plaza at 9:57 p.m. according to the data from Smart Tech device that was confiscated from the second respondent. The first respondent called Punca Alam according to the phone records from the witnesses, which logically suggests that the first respondent was with the second respondent scaling Punca Alam tolls. The presence of witness at the crime scene beforehand of the murder suggests that someone arrived sooner than expected after becoming aware of Atlantria's activities right before she was murdered. The second factor is the vehicle used for transportation. This is the same vehicle used to convey the dead bodies, and also whether slippers with blood stain was evidence was found. Next is the case of T. Hock Keong and Public Prosecutor. A police MPB squad was sent to the location of the incident. 2 police officers saw an unconscious person lying on the road behind a factory bus stop when the MPB team got to the area. One of the witnesses, Sheikh Abdullah bin Rosli, said that on that early evening, he received a call from a man named Ahang requesting him to visit the flat. And the preparation in this case can be seen when the appellant called the co-counsel to help him with this crime abatement.
In short, preparation is the second element needed to be proven after the establishment of motive pursuant to Section 8 of the Evidence Act 1950. Preparation is an act or series of acts made prior to the attempt to commit a crime. Although preparation itself does not constitute to a crime, preparing to commit a crime is not in and of itself a lawful conduct, but the fact that it was done acts as a crucial piece of evidence or information that will be useful in the event that the crime is carried out. Thus, any piece of evidence that shows the preparation on the part of the accused to commit his crime is admissible. However, preparation cannot be considered as an attempt to commit. Unlike preparation, an attempt is a person's direct and intentional action to commit a crime. Preparation does not inflict harm nor it disturbs the public, as it is only an preliminary initiation of a certain action that is generally not punishable by law.
Hello everyone, my name is Afiq Syafi and I'll be explaining on conduct. Section 8 clause 2 states that the conduct of any party of any agent or party to any suit or proceeding in reference to that suit or proceeding or in reference to any fact in issue therein or relevant thereto, and the conduct of any person, an offence against whom is the subject of any proceeding, is relevant if the conduct influences or is influenced by any fact in issue or relevant fact, and whether it was previous or subsequent thereto. In the case of Bhuta Singh against Public Prosecutor, a report was made by the deceased to the police against the accused several months before the deceased murders. Therefore, it is not admissible under Section 32 of the Evidence Act 1950. However, in accordance to Section 8, it may be presented in court. This is not for the purpose of proving that the deceased's allegations against the prisoner were true, but rather it is to demonstrate the nature of the relationship between the appellant and the deceased. So to conclude everything, in order for evidence to be relevant in the committing of a crime, it is necessary to establish 3 elements listed in Section 8 of the Evidence Act, and those are motive, preparation, and conduct. Despite the fact that this section cannot be used to prove a crime, it can be utilized as a support for convicting a crime, since it identifies the motive or mens rea portion on the accused for wrongful behavior that was done. When each of these 3 requirements are met, it will be possible to build a prima facie case. That is all from me. Thank you.